Good afternoon, and thank you all very, very much for attending today to listen to Helen and I discuss the much anticipated Court of Appeal judgment in Swift and Carpenter. A very warm welcome to you all from Helen and I. So often, when a claimant suffers a catastrophic injury, he or she will require new accommodation, which may be single level accommodation or larger accommodation to accommodate a carer or therapy rooms. Usually, that new accommodation will cost more than the claimant's existing accommodation. However, the amount awarded has never been the difference between the value of the new accommodation over the value of the existing home. This is because a home is an asset which generally appreciates over time, and to allow the full additional cost would leave the extra value in the hands of the claimant or the claimant's estate when it is no longer needed, and thus would be a windfall. The central problem is how to avoid overcompensation. And the award has traditionally been calculated as compensation for the claimant's inability to invest the money that he or she now has tied up in the property, as he or she may want to invest that money. And the conventional formula for valuing this was confirmed in the case of Roberts and Johnstone. And the formula was based on the difference in price between the old property and the new property, the relevant multiplier, and the discount rate. So take as an example a 30-year-old man who required new accommodation after a road traffic accident, normal life expectancy. His pre-injury property was 500,000, and he required a property worth £1 million after the accident. His life multiplier on the basis of using Ogden 8 on 2.5%, which is the discount rate that was prevalent for a long time, was 29.53, and at minus 0.25%, it's 59.75. So the Roberts and Johnstone calculation that would have been the additional capital, which is the $500,000, times the discount rate, times the relevant multiplier, and that came to a figure of £369,125. However, the problem occurred in February 2017, when the discount rate reduced to minus 0.75% before it then increased again to 0.25%. And we can see what happens with this calculation when we have a negative discount rate. So the 500,000 times minus 0.25% times the relevant multiplier, which is higher to reflect the minus 0.25% discount rate, comes out as a negative number. And so that was the problem. It just meant that claimants no longer would get any sum for additional capital cost. So instead of giving claimants a windfall, they would often not be able to even fund buying a new accommodation, or would have to use funds that they'd been given for other heads of loss in order to fund it. And this is what came to a head in Swift and Carpenter.
Thank you very much, Nina, and hello, everyone. Yes, the problem did come before the court in Swift and Carpenter, and I think before we look at the Court of Appeal decision, it's worth just reminding ourselves of what happened at first instance before Mrs. Justice Lambert. The case was in many ways perfect for an appeal because the facts were straightforward, and they very neatly illustrated the difficulties with Roberts and Johnstone, which Nina has alluded to. So the facts were, first of all, the claimant was aged 39 when she was involved in a road traffic accident on the M5 in October 2013. She was a front seat passenger being driven by her partner, who in fact was the defendant, Mr. Carpenter. He was married by, they were both married by the time of trial, but she clearly kept her maiden name because the case is not Carpenter and Carpenter. Anyway, Ms. Swift suffered very serious lower limb injuries, including a below-knee amputation of the left leg, and her right foot was also very badly injured. She had a normal life expectancy of 45.43 years at the time of trial. She looked for a lump sum award, and it was agreed by both parties that that was appropriate. At the time, a minus 0.75% discount rate applied, which gave her a life multiplier of 55.02. Now, at the time of the accident, the claimant, Ms. Swift, had recently bought a home in Brackenbury Village in West London, an area described by Mrs. Justice Lambert as a leafy and attractive part of West London. The house was in her sole name, again, something which simplified things. And it was a Victorian mid-terrace 3-bedroom house set over 3 floors. Mrs. Justice Lambert said that she found that the current value of that house was 1.45 million. And she didn't accept that the claimant would have moved house in any event. Given, though, that there aren't many bungalows in West London, it was agreed between the experts that a much larger property would be needed so that a lift could be installed between the floors. And it still had to be in an attractive and pleasant location in West London with good transport links and close to the tube, because Ms. Swift walked there in order to go to work each day. Mrs. Justice Lambert found that the cost of suitable accommodation was likely to be in the order of 2.35 million. So that's a difference of 900,000. Given that the minus 0.75% discount rate to be applied for the purposes of calculating the multipliers would, according to Roberts, mean that she recovered a nil award, that was the issue before Mrs. Justice Lambert. Now, the defendant contended that the court was bound by Roberts and Johnstone. The claimant said no and invited the court to adopt a different approach and formulation consistent with the principle of full restitution. Now, there were 4 alternative formula which were put forward in the schedule of loss. None of them were linked to the calculation of the multiplicand and the current discount rate. And Mrs. Justice Lambert found that they were all inappropriate. I won't go into detail about what they all were because Nina is going to look at the different options that were on the table next. But in essence, none of those worked. Each formulation produced the windfall, which Roberts and Johnstone was so keen to avoid. But the key problem for Mrs. Justice Lambert is that she was bound by Roberts and Johnstone. There was no sufficient reason to depart from it. And on that basis, the claimant was awarded nothing for the capital cost of the property. She was, though, of course, awarded the cost of alterations, furnishings and fittings and moving and so on. Mrs. Justice Lambert recognised that the situation couldn't continue, and she granted permission to appeal. She said that there was an important point of principle which the Court of Appeal needs to resolve. That is, whether the Roberts and Johnstone formula remains consistent with the principle of full restitution. She noted that even though the current discount rate at that time, so the minus 0.75%, may increase, such as to produce some relatively modest damages in respect of additional capital costs, it would still produce anomalous results because it did even when it was at 2.5%. So on that basis, permission to appeal was granted. And I have to say that Lord Justice Underhill later described the approach of Mrs. Justice Lambert as exactly the right thing, indeed by following Roberts and Johnstone, but drawing attention to the problems with it and giving permission to appeal. I'm now going to hand back to Nina, who's going to look at the path that the appeal took.
Thank you, Helen. As Helen said, Mrs. Justice Lambert gave the claimant permission to appeal so that the Court of Appeal could review the law in this area. And PIBA was also given permission to intervene on the appeal. The Court of Appeal permitted expert evidence from economists, actuaries, mortgage experts, and experts in the valuation of reversionary interests in property. And that expert evidence hadn't been adduced in the court below, but the Court of Appeal felt that this was the time to grasp the nettle and to resolve this issue. And so they felt they needed the expert evidence and that it was justified to permit it at this stage. Helen referred to a number of options that had been put forward in the schedules of loss and counter schedules below. But by the time the expert evidence was exchanged and joint statements were prepared, the parties agreed that these following options weren't viable. The first was an interest-only mortgage backed by a PPO. Well, the reality was there just wasn't a mortgage product available for Miss Swift. The life multiplier times mortgage payments or mortgage interest payments or rental costs, these all worked out too expensive and actually were more money than the additional capital cost in the first place. And the other issue, the other suggestion that had been put forward was a loan from the defendant to the claimant with a charge on the property. But the defendant wasn't regulated in order to provide that loan. So these were all abandoned in this particular case. That's not to say that they couldn't be resurrected in other cases, in other suitable cases, and perhaps a short life expectancy case might be one where there's a relevant product available, and these could be looked at further. So the parties did agree that one possible way of valuing the additional capital cost would be the additional capital required minus the value of the reversionary interest in the property. So what is a reversionary interest? Well, it's an interest that is finite, usually in time, commonly in real estate, commonly used in a trust over a house. So let's assume that Bob wants to create a trust in respect of property to benefit his wife, Claire, and his child, Olive. Bob would create a trust giving his wife, Claire, a life interest in the house. And then when Claire passed away, then the reversionary interest will pass to the child, Olive. So in that situation, Claire is the main beneficiary of the property and will take control of the property now. And Olive is what was referred to in the judgment as the remainder man. The interest that Olive will gain does have a value, and it might be, for instance, that Olive wants that money now. And if she did, the Court of Appeal heard that there is actually a small but real market for reversionary interests. And the parties agreed that the reversionary interest was the best way of trying to value the shortfall. But the question was how on earth that would be valued. So the issues that were agreed that had to be decided was whether the Court of Appeal was bound to apply Roberts and Johnstone, which was a Court of Appeal case in itself. And to answer this, the Court of Appeal had to ask itself, does it apply? Can it revisit Roberts and Johnstone? If so, should it revisit it? And if the Court of Appeal is permitted to re-examine the approach in Roberts, should the court award the full capital value of the incremental sum required, or should the court award that sum but reduce to reflect the value of the notional reversionary interest? i.e. the value of the windfall? And if 2B is correct, how should the court value the reversionary interest? The appellant's arguments were that Roberts and Johnstone was not binding, that it was guidance, that it didn't have the force of statute and was not a binding statement of law. And they said it was a pragmatic solution at the time, which was no longer pragmatic, and that it produced an unfair result in the economic circumstances. And in that case, and in that situation, it should not be followed anymore. They emphasised that the primary objective must be to compensate the claimant, and the avoidance of a windfall, whilst important, should not be paramount. And they said that the claimant should get the full additional capital cost, or if not, then the capital cost less the market value of the reversion. And the market value of the reversion was based on the evidence of an expert called Mr. Watson, who I believe was Peeber's expert. And he gave evidence that it's an extremely small market. I think he might be one of the only people that actually deals in it, but it's a real market, but tiny. And he's the only expert in that area. The respondents' arguments were that Roberts and Johnstone is binding, and not only that, but if it's not binding, it should be followed anyway, because it actually does produce a fair result. They didn't agree that it produced the unfair result that has been suggested. And the reason that they say that, they had an interesting argument, and it was based on the principle of equity release. And so what they said is that the claimant can buy the property that the claimant needs out of the damages that have been awarded, including damages for the other heads of loss. And then as she requires further money later in life, as those damages might be going out, she can then release equity from that capital asset to raise money later in life. So there's in fact no loss, they say. And that's the cash flow model. Alternatively, they said that it should be valued not by the market value, but by the fair and reasonable value, which was based on their expert, Mr. Robinson. And that's the way that trusts are usually valued when they're wound up. And the problem with that is it was quite a complex calculation, and it will be different in different situations, and it will always require actuarial expert evidence. So I'll now hand over to Helen to explain what the Court of Appeal found.
Yes, that's right, Nina, thank you. So what did the Court of Appeal make of all of those arguments? Well, the first issue that Nina referred to is whether or not Roberts and Johnstone applied. And the Court of Appeal said that it did. The key point the Court of Appeal had to grapple with here was whether Roberts and Johnstone represented authoritative guidance or legal principle. Because, of course, if it was legal principle, then the Court of Appeal couldn't overturn it, because the Court of Appeal can't overrule its own decisions on points of law. That stems back from the case of Young and Bristol Aeroplane in 1944. It was decided that it wasn't legal principle, but it was authoritative guidance from the Court of Appeal as to how the courts should comply with the legal principle of fair and reasonable compensation, but not overcompensation. It was found that the authoritative guidance was given in the specific conditions prevailing at the time of the decision. And as Lord Justice Irwin put it, the formula was a means to an end rather than a principle or end in itself. In this respect, it's worth noting that a comparison was drawn with the case of Noah and the Ministry of Justice, in which the Supreme Court considered the proper approach to multipliers in Fatal Accident Act claims. Now, the House of Lords in Cookson and Knowles had held that the multiplier should be fixed as at the time of death, not the date of trial. Now, that was found to be a legal principle, not just a guideline. And so in that case, in Noah, it required the Supreme Court to invoke the practice direction on judicial precedent so that it could declare that it was able to depart from a previous decision. Hence, of course, we know that the law changed in Noah, and we know that the date of calculation of the multiplier in Fatal Accidents Act cases has changed to the date of trial. In this situation, the court said that it was different, it wasn't legal principle. So the next issue then, on the next slide, could Roberts and Johnstone be revisited? Well, again, yes, it could. It was said by Lord Justice Owen, if that guidance is demonstrated now to be ineffective in achieving the object of the relevant principles of law, namely full compensation without overcompensation, then this court can revisit and alter such guidance. The next issue on the next slide, should Roberts and Johnstone be revisited? Well, again, yes. All three judges agreed that it was appropriate for the court to revisit it because it no longer provided a fair way of calculating compensation in modern economic circumstances. That was plain. It was said again by Lord Justice Owen, it cannot be regarded as full, fair or reasonable compensation to award nil damages in respect of a large established need on the basis that if all the relevant predictions hold good over many decades to come, there will arise a windfall to a claimant's estate. He said the approach is no longer capable in modern conditions of delivering fair and reasonable compensation to a claimant, because of course we know the claimant would receive no award whatsoever in respect of their accommodation needs. Just moving on to the next slide, it was argued that Roberts and Johnstone remained appropriate because, as Nina has said, the cash flow analysis applied. So the claimant could, following trial, borrow from other pots of damages in the short term to fund property, and then later on towards the end of life, release cash by equity release from the property. But that cash flow analysis argument was also rejected. The court found it comprised such a level of conjecture, such complexity and such uncertainty of outcome, it couldn't be demonstrated to achieve fair and reasonable compensation. Davis also noted that the proposed course undermined the principle of full and fair compensation, and she said that it would do so at a time of particular vulnerability for a claimant by reason of her age and disability. It also ran counter to the multiplicand approach of calculating an award under discrete heads of loss. It was also found that the cash flow analysis approach would alter a claimant's investment profile. So they would be required to invest in property, and that might of itself necessitate revision of the discount rate to be applied to the remainder of the award. Now, we don't want to get into that complexity. We want to keep things simple. And then finally, they said that tying up funds in property would constrain a claimant's capacity to protect themselves from future contingencies. And it offended the principle that it's actually for the claimant to decide how to invest their damages. They don't want to invest it in capital at the start. They shouldn't be required to do so. Lord Justice Owen then turned to the windfall argument, and he said that that shouldn't be permitted to distract from the need for fair and reasonable compensation. He felt that this was really putting the cart before the horse. And he said, but to withhold all damages for the purpose of avoiding an eventual windfall seems to me to put a secondary principle before a primary principle, to put the cart before the horse. So moving to the next slide, the next issue was should the full capital value of the incremental sum, so i.e. the difference between the existing property and a property which was required, be awarded? And they said no. There were two key principles of law by which the court was bound. First, that a claimant injured by the fault of another is entitled to fair and reasonable, but not excessive compensation. And the second was the corollary of that principle, which was that in relation to accommodation, the award of damages should seek so far as possible to avoid a windfall to a claimant, or in fact, more realistically, to his or her estate. Another way of expressing this, as Lady Justice Nicola Davis did, was she said, at the core of the determination of this court is the principle of law that a claimant is entitled to full and fair compensation for injury sustained as a result of the defendant's tort. The purpose of the damages is to place that claimant as far as is reasonably possible in a position he or she would have been absent the injury. But it doesn't entitle the claimant to be compensated for more than the loss which has been sustained. So applying those two principles in long life expectancy cases, they held it wasn't appropriate for the court simply to award the full capital value of the incremental sum, but rather if there was a fair and workable means of avoiding that windfall, then that should be adopted. So turning to the next slide, and this relates to the fair and workable means. Should the court award the full capital value of the incremental sum, but reduced to reflect the value of the notional reversionary interest, so the value of the windfall? They said yes. And it was accepted that windfall should be avoided if at all possible. And in fact, there was then agreement between the parties that the appropriate way to avoid that windfall was by valuing the notional reversionary interest. So there was no particular dispute here. But moving on to the next slide, of course, there was a dispute about exactly how you value that reversionary interest. And Nina had explained the two different arguments that were raised, either the market value assessment or the fair and reasonable assessment. And the court went with the market value assessment. It noted that there was a small market, as Nina has also referred to, but the court seemed to take the view that the market value assessment would give greater certainty and consistency, and that was crucial for claimants and also for advisors. So if we move on to the next slide, how should the present value of the notional reversionary interest be calculated? Well, effectively, what that means is identifying an annual percentage rate by which the value should be discounted for the period between the assessment and the claimant's predicted date of death. So the formula is to calculate the reversionary interest. You look at the value of the property required, so that's P, minus the value of the property owned but for the accident, so that's B, and then multiplied by 1.05, that's the 5% rate, to the negative power of the life expectancy. So L is the life expectancy. So it's really just the same approach as you would use for an item of equipment that was required in X number of years. That's really what the equation means. We're looking at the value of the reversionary interest, applying a discount factor, which the Court of Appeal has set at 5%. So if we move on to the next slide, we can see what that actually meant, what the result of that was on the facts of the case. So as I said before, Mrs. Justice Lambert had found that the value of the property that was required by Ms. Swift was 2.35 million. The value of the property that she owned and would have continued to own but for the accident was 1.45. So the difference was £900,000. Her life expectancy was 45.43 years. So that's just simply looking at the table 2 0% column. So to value the reversionary interest, you do the 2.35 million, take away the 1.45, 900,000, times 1.05 to the power of negative 45.43. And then that gave the reversionary interest value as £98,087. So then the damages awarded for the capital costs were the 900,000 minus the value of the reversionary interest, the 98,087. So it came out as £801,913. Now, there are ways of calculating to the powers of just using the upside down V symbol on a calculator. But another very straightforward way of doing it is simply to look at the 5% discount rate table in table 35. So this was previously table 27. And if you look at an old edition of the Ogden tables, I think it's Ogden tables 5th edition, table 27, 5% column, follow that column down to the number of years of life expectancy left, and you get the figure. The PNBA have produced a ready reckoner, and we've been told that that ready reckoner will also be produced in the new edition of Facts and Figures. I'm going to hand over now to Nina, who's going to talk through some examples.
Well, thank you very much, Helen. So, yes, the case of Swift was in fact factually a very straightforward case, which made it good for the Court of Appeal to use as a test case. However, not all of our cases are so straightforward, and Helen and I were going to look at a few examples of how we can apply this in practice, and also some of the limitations of the judgment. So example 1, this is a 65-year-old female claimant with spinal injuries following an RTA with a life expectancy of 80. She requires a bungalow that now is worth for £1 million, and her pre-injury home was worth £500,000. She was owned jointly with her husband. So applying the Swift and Carpenter formula, we work out the claimant's share in her old home, which was £250,000 because she owned that jointly with her husband. And so then we use the formula that Helen has just explained. So the value of the reversionary interest is 1 million minus the 250,000 times 1.5 to the power of minus 15, because that's her life expectancy. And note there that it's not a life multiplier like we know it, it's actually the actual figure, 15 years. Between 65 and 80 is 15, and that comes to 360,762.82. So the damages for the capital cost is the 1 million minus 250,000 minus that reversionary interest of 360,762.82, which comes to £389,237.18. And I thought it was useful to put up the old Robert and Johnstone calculation as well, just so that we can compare the two. Now, obviously, the R&J calculation is at 2.5%, because no point me giving an example of a minus discount rate because it would come out as 0. So at 2.5% with the the difference in price, the 750,000 times 2.5% times 12.54, which was the life multiplier, would be 235,125. So we can see that the claimant has done better with the new Swift multiplier. Oops, so going that wrong way. But question, in that situation, what if there is a possibility that that claimant will go into a care home at the age of 75? So she won't need that accommodation for the whole of her life expectancy. She won't need it for the whole of that 15 years. Is using the life expectancy in that calculation appropriate when the need for accommodation will cease before the end of her life? Well, Lord Justice Underhill considered this briefly, paragraph 229, and he said there must always be a possibility that the claimant's need for the additional element in their accommodation will come to an end or the cost of it be reduced at a date significantly earlier than death. For example, if they move to a cheaper property later in life, or live their last years in a nursing home or with a relative. In such a case, there would be a release of capital at that point, and a valuation on the basis that a notional reversion falls in only at the date of death will result in overcompensation. Lord Justice Irwin acknowledges that possibility, but says it will only occur rarely. I'm not sure I agree about that. However, I would still agree with him that the reversion should be valued at the predicted date of death, except perhaps in unusual circumstances where the possibility of a substantially earlier release of capital was high. The modest degree of overcompensation which a valuation based on life expectancy would entail is, in my view, justifiable by the needs of practical justice. And I think that echoes the guiding principles of the judgment, that the aim is fair compensation, but overcompensation trumps undercompensation, and that the aim is for their aim was to provide a simple calculation where possible. So it seems that the default really is life expectancy in the calculation. And they don't seem to be inclined to tinker about with the periods over if it's just a short period one way or the other. I think they think that the simplicity of the formula justifies any slight inaccuracy with the figures. However, it clearly does leave the door open to departing from Swift and Carpenter in the right situation. And I would say that if you have a case where there are you've got very strong evidence that a claimant will not need their accommodation after a certain time, then you might be able to argue that Swift and Carpenter doesn't apply. But I would say that the more uncertain that prospect is, and the closer it is to the claimant's death, the less likely the court will be to say that the Swift and Carpenter formulation doesn't apply. So the second example, this is a female claimant aged 11 who suffered a brain injury at birth. She's got a normal life expectancy, which is 78.99, using Ogden 8 table 2. And if you use the 0% column, that gives you the life expectancy. She requires 24-hour care. She will continue to live with her parents for the foreseeable future. And she requires adapted accommodation, which is going to cost £450,000. So to work out the reversionary interest in that, it's £450,000 minus her parents' accommodation. You don't take that into account, so that's 0 times 1.5 to the power of minus 78.99, which is £9,538.27, and then the additional capital cost would be £450,000 minus the reversionary interest, which comes out at £440,461.73. And again, I've worked it out with the old Robertson Johnstone calculation, and at 2.5%, that would have been 387,112.50. So again, clearly there's a difference in discount rates, but the claimant has done better under the Swift and Carpenter. But what if the judge finds that absent the injury at age 28, the claimant would have bought a property for £125,000? So the but-for situation, if the claimant hadn't been injured, what would she have done? Would she have gone on and bought a house? And if the judge finds that at the age of 28, she would have bought a property for £125,000 with a partner, to 50% share of £250,000, how do you do that calculation? Well, the judgment doesn't say, and in fact there were some paradigm examples that were put before the Court of Appeal, and one of them actually had this scenario in it, and the Court of Appeal just didn't tackle it at all. So the judgment doesn't tell us the answer. So is the calculation that you £450,000, which is the price of the new property, minus the claimant's share of the £250,000 property, 125,000, times 1.05 to the power of 78.99, and do it that way? Or do you split the periods as you would have done with the old Roberts and Johnstone calculation, where you would have split the calculation from the time of trial up until the age when the claimant would have got the property, and then you do another calculation from that age onwards? So do you split the life expectancy? Well, we don't know. And it's not clear. There was a PEBA seminar last night, and Darrell Allen QC, who appeared on behalf of PEBA, the intervener, he had worked out this. He'd done the split calculation, and he thought it probably wouldn't be appropriate because it does come to some slightly strange results. So it's possibly the first one seems most likely, but we just don't know. So there is definitely argument here in the future. And then, of course, there's a question of whether the claimant would have bought two properties, would have bought a property, a starter property, and then a property later. Do you take a weighted average of the two values, or do you just use the later value of the property? Again, these aren't answers that we've been given, so there is still lots of areas for negotiation here. Another question is betterment. So how do you deal with betterment? So you require a property, the claimant requires a property of £1 million. Their pre-injury accommodation was £500,000, and their life expectancy is 30 years. But once, the evidence is that once they've done all their adaptations and extended the property and put in the new bathrooms and kitchens, that actually the property will be worth £1,100,000. How do you give credit, or do you at all give credit for the betterment in the Swift and Carpenter calculation? Again, this is something that is not discussed in the judgment, and there was no betterment in the Swift case. There are two arguments here. One is that you give no credit, and one is that you do give credit. And the argument for no credit would be that, well, you're focusing on the point of purchase, so that the claimant might want to sell their reversionary interest straight away on the open market in order to obtain the additional capital cost. And if they were to do that, they should be able to do that and be fully compensated. And there is no betterment at that stage. So the reversionary interest should be valued at the purchase price. And the other way of looking at it is, well, no, actually, eventually the claimant's going to have an asset that's worth £100,000 more. And so they should give credit for that. And the second way to work that one out would be to use the 1 million plus the 100,000 betterment, and take away then the pre-injury accommodation, and then apply the discount to get the reversionary interest. But note there, when you take away the reversionary interest, you don't take it away from the 1 million plus 100,000. You just take it away from the shortfall, because that's what we're focusing on. It's the capital shortfall, and you have to take off the reversionary interest from that. A further issue that's not covered in the judgment, because it just wasn't appropriate on the facts, but they didn't discuss it, was renting, where there's required, where the claimant had been renting before the accident. So they don't have a pre-injury home to value. So there's nothing to put in the pre-injury home part of the equation. But they were living somewhere and they were spending money on their accommodation. So let's just say there was somebody who had a life expectancy of 30 years and they were spending £10,000 per year on rental prior to the accident. With that over a lifetime using Ogden 8 comes to 311,600. That's what they would have spent. So how do you give credit for that? Because clearly they should do. Do you substitute the 311,600 for the pre-injury home value in the calculation? Or do you do it as a second step? So if you do it the first way, you see that you come out with a figure of 144,808.49. But to do it as a second step, so for instance, you use you actually use the calculation, so the pre-injury home value of 0 to find out the reversionary interest, as Swift and Carpenter says. So you work that out, it's 0, comes to 115,688.72, and then the additional capital cost comes out at 384,311.28, and then at the end you take off the rental, and that comes out, as you can see, as a much lower sum of 72,611.28. Now at the PEBA seminar last night, Darrell Allen did express the view that he felt that the first one of those options, so the substituting the rent for pre-injury home, would be inappropriate, and he thought that the second step was probably the most appropriate way, and that is because conceptually it doesn't really work to substitute the rental for the pre-injury home value, because when you rent at the end of your life, you don't have an interest in a property. That money's all gone, and so you're mixing two things to start deducting the 311 when what we're looking at is the reversionary interest in homes. So the second is probably the way to do it, but again, lots of room for negotiation here because we don't know, and there may be other ways as well of doing it. So I'm now going to hand over to Helen to talk about short life expectancy cases.
That's right, Nina, thank you. So how does the new formula work in the case of someone with a short life expectancy? Well, on the slide there, you'll see that I have compared the case of a person with a 5-year life expectancy with someone with a 20-year life expectancy, using the same figures for the value of the property that person needs and the value of the current property. Now, the person with the 5-year life expectancy would get £97,425 damages, but the person with the 20-year life expectancy would get about 3 times that, £280,395. So moving on to the next slide, we can see that the Court of Appeal recognised that the new approach, the new formula in Swift, would not necessarily be appropriate in cases of those with a short life expectancy. So Lord Justice Irwin, I've quoted what he said at paragraph 210. He accepted the submission of PEBA that the guidance shouldn't be regarded as a straitjacket to be applied universally and rigidly. There may be cases where this guidance is inappropriate. However, for longer lives, during conditions of negative or low positive discount rates, the guidance should be regarded as enduring. So that seems to say that for shorter lives, it wouldn't necessarily be appropriate to apply the guidance. And again, Lord Justice Underhill emphasised that he was only concerned with a case of the present kind, so a case like Ms. Swift's, where a claimant has a long life expectancy. And he said the position will be different in short life expectancy cases of the kind illustrated by paradigm 3. And that's, Nina mentioned earlier, the different paradigm cases that the court considered and that are attached to the end of the judgment. So it's likely, we think, to be successfully argued that the judgment doesn't apply in short life expectancy cases. And as Nina said, the priority of the Court of Appeal was to compensate for the loss. The risk of overcompensation is less important, it seemed, to the Court of Appeal than the risk of undercompensation. So the thrust seems to have been that had the Court of Appeal not been able to account for the windfall in a way that they thought was fair for the claimant, so with the reversionary interest method, they would have awarded the full difference in value. It seems likely that we will have to watch this space and wait for judgments which grapple with the issue of just how short the life expectancy has to be before it's appropriate to depart from Swift. But of course, in the meantime, many cases will be settled, and it seems inevitable that when those settlement discussions take place, the same arguments that have been raised to date will be made. So things like it would be more appropriate to rent than to purchase a property, because of course, imagine the case of Swift. If she'd only had a short life expectancy, that would be a huge windfall, £900,000 to her estate if, say, her life expectancy had been 4 years or so. And remember, in relation to rent, the reason that that argument didn't work in her case was because the cost of rent throughout a long life expectancy case will end up being much more than the capital value often. But in a short life expectancy case, it could work. So that's it. We hope that we've explained the decision and some of its ramifications. No doubt there are many other ramifications which we've not yet appreciated. What's clear is that although Swift should be welcomed, I think, in the sense that those with longer life expectancies are now properly and reasonably compensated for capital costs, it hasn't resolved all of the issues which arise in this tricky area, especially in relation to short life expectancies. So thank you very much. If you have any queries, please do email me or Nina. I think our email addresses were put up on the slide, and you can get them via the website. Thank you. Goodbye.